Your green card is in your wallet right now, but is it actually safe? Because in the last few weeks, thousands of permanent residents just like you have been stopped at the border, received unexpected letters from USCIS, and flagged by the IRS for things they did not even know were a problem. And the scariest part? Most of them had no idea any of this was coming. I am not here to scare you. I am here to make sure you are not caught off guard. Because the 5 changes happening right now in 2026 are real. And if you hold a green card, the next 10 minutes could genuinely protect your status, your travel, and your future in the United States. So before you close this video, before you go back to scrolling, give me just a few minutes. Because what you are about to hear is something every green card holder in America needs to know right now. Welcome back. If this is your first time here, this channel is called Immigration Law Station, and what we do here is simple. We take complicated immigration topics, we remove the rumors, we remove the panic, and we give you calm, fact-based, clearly explained information so that you can make smart decisions. No political opinions, no exaggeration, just real information you can actually use. Now, today's topic is one that has been generating a lot of anxiety inside green card holder communities. And honestly, that anxiety is understandable. There is a lot of noise right now. But noise and facts are two very different things. And by the time this video ends, you are going to know exactly which changes in 2026 are real, which ones affect you directly, and what, if anything, you actually need to do about them. So let us start from the beginning. A green card, officially called a permanent resident card, gives you the legal right to live and work in the United States permanently. But the word permanently does not mean unconditionally. There are rules that come with it. Rules about how you behave, how you pay taxes, how long you can stay outside the country, and how you maintain your status. Most green card holders already know the basic rules. What is causing confusion right now is that some of those rules are being more strictly enforced in 2026, some new administrative policies have been introduced, and some existing rules that were largely ignored for years are suddenly getting real attention. Let us go through each one clearly. The first change that is affecting green card holders in 2026 relates to tax compliance and foreign financial disclosures. Now, this is not a new law. This has been the rule for many years. But what has changed is the level of enforcement and the attention being paid to it. If you are a green card holder, the United States Internal Revenue Service, the IRS, treats you as a tax resident. That means you are required to report your worldwide income to the IRS, not just the income you earn inside the United States. If you have a bank account in your home country, a property you are renting out, a business, investments, or any source of income outside the United States, all of that is subject to U.S. tax reporting obligations. On top of that, if you have foreign bank accounts with a combined value of more than $10,000 at any point during the year, you are required to file what is called an FBAR, which stands for Foreign Bank Account Report. This is filed separately from your regular tax return. There is also a related requirement under a law called FATCA, which requires certain foreign financial institutions to report U.S. account holders to the IRS. What this means practically is that even if you do not voluntarily report your foreign accounts, your foreign bank might already be doing it automatically. The reason this is coming up so strongly in 2026 is that enforcement has increased significantly. The IRS and CBP, which is Customs and Border Protection, have been coordinating more closely on identifying green card holders who have significant foreign financial ties but have not been filing the proper reports. Some green card holders have received notices, some have faced penalties, and a small number have seen this come up as an issue at the border when returning to the United States. What you should do is make sure your tax filings are current and accurate. If you are unsure whether you have been filing correctly, speak with a licensed tax professional who has experience with international tax issues. This is not about panic. The majority of green card holders who file correctly have absolutely nothing to worry about. But if there are gaps in your filing history, it is far better to address them voluntarily than to wait for an enforcement action. The second change involves international travel and the rules around extended absences. This is another area where the rules themselves have not completely changed, but the scrutiny has increased significantly in 2026. As a green card holder, you are allowed to travel internationally, but your green card is not a guarantee of re-entry into the United States if you have been outside the country for extended periods. If you stay outside the United States for 6 months or more in a single trip, you can face questions from Customs and Border Protection officers at the port of entry. If you stay outside for 1 year or more without a re-entry permit, you risk being found to have abandoned your permanent resident status. What has changed in 2026 is the way CBP officers are being instructed to approach these cases. There is now more consistent documentation of absence patterns, and officers are more likely to formally question travelers who have been outside the country for more than 6 months, even if they have a valid green card and have not yet hit the 1-year mark. They may ask about your job, your home, your family ties, your financial connections to the United States. They are trying to determine whether the United States is still your primary place of residence. If you travel frequently for work or family reasons and you sometimes spend more than 6 months abroad, the safest tool available to you is a re-entry permit. You apply for it using Form I-131 before you leave the United States. It is issued by USCIS and it gives you documented permission to remain outside for up to 2 years without abandoning your green card. It does not guarantee re-entry, but it is strong evidence that you did not intend to abandon your status. The rumor going around social media is that green cards are being canceled at the border for minor travel. That is not accurate. A CBP officer cannot cancel your green card on the spot. They can refer you to secondary inspection. They can issue a document called an expedited removal in extreme cases, but that involves a formal process and legal rights. The exaggerated social media version of this story is causing unnecessary fear. Understand your rights. Carry documentation of your ties to the United States, and if you are a frequent traveler, get a re-entry permit. That is the calm, practical answer. The third change involves continuous residence requirements for naturalization. If you are a green card holder planning to apply for U.S. citizenship, you need to have maintained continuous residence in the United States for a required period, usually 5 years or 3 years if you are married to a U.S. citizen. In 2026, USCIS has updated its internal guidance on how officers review travel history during naturalization interviews. Officers are now more carefully examining whether long trips abroad broke the applicant's continuous residence, even if individual trips were each under 6 months. What this means in practice is that if you took several trips that were each 5 months long over the past 5 years, USCIS may add those up and look at the total picture of your physical presence and your ties to the United States during that time. They want to see that your life has genuinely been centered in the United States. This is not a new standard, but the level of scrutiny in adjudication has increased. If you are getting ready to file for naturalization and you have spent significant time abroad, it is worth reviewing your travel record carefully before you file. USCIS uses your passport history, your tax returns, your employment records, and sometimes social media as part of that review. The fourth change relates to public benefits and the public charge ground of inadmissibility. Now, this is one of the most misunderstood topics in all of U.S. immigration, and social media has made it even more confusing. Let us be very clear about what the current rule actually says. Most green card holders are not subject to the public charge test anymore once they have their green card. The public charge assessment primarily applies at the time someone is applying for a green card, not after. However, there are exceptions. Certain categories of people can still be reviewed under public charge rules if they travel outside the United States for extended periods and are then seeking re-entry. In 2026, the policy guidance around this has been clarified in a way that makes it more relevant for green card holders who have been outside the country and who have used certain federal benefits while abroad or in certain circumstances. The key distinction is between benefits that count under public charge rules and those that do not. Medicaid in most circumstances can be a factor. Emergency Medicaid, CHIP, school nutrition programs, and many other programs are explicitly not counted. If you are unsure what applies to your specific situation, USCIS has published guidance on this at uscis.gov, and that is always the most reliable place to check. The fifth change involves green card renewals and the processing environment at USCIS in 2026. Green cards issued for 10 years need to be renewed. Green cards issued for 2 years, which are typically given to conditional residents based on marriage or investment, need to have the conditions removed before the 2 years expire. In 2026, processing times at USCIS remain significantly backed up. That is not a new problem, but it is an ongoing reality that every green card holder needs to plan around. The important update for 2026 is that USCIS has adjusted how it handles extension notices for applicants who filed to remove conditions or renew before expiration. If your card has expired but you filed your renewal on time, USCIS issues what are called automatic extension notices. These notices serve as temporary evidence of your continued legal status while your case is pending. CBP and employers are supposed to accept these notices as valid. The problem is that not every employer and not every CBP officer is equally aware of this policy, which is causing real-world confusion. If you are in this situation, carry your filing receipt, your extension notice, and your expired green card together at all times. That combination is your documentation of valid status. There has also been a significant increase in requests for evidence during the renewal process in 2026, which means USCIS is sending more letters asking applicants to submit additional documentation before approving their cases. This is not a denial. It is a request. Respond to it carefully and completely within the given time frame. Now let us take a moment to address the broader fear in the room. You have seen headlines. You have heard stories. You may have friends or family members who are genuinely scared right now. Here is what you need to hear. Immigration rules in the United States do not change overnight. There are administrative processes, legal procedures, court systems, and oversight mechanisms that exist specifically to prevent sudden, unlawful mass action against lawfully documented residents. Green card holders have legal rights in the United States. If you follow the rules of your status and stay informed, your situation is manageable. The best things you can do right now are practical and calm. Make sure your taxes are filed correctly and that any foreign financial accounts are properly reported. Be thoughtful about how long you spend outside the United States and document your ties to the country. If you are approaching naturalization eligibility, review your travel record and consult a licensed immigration attorney before you file. If your green card is expiring, file early and keep your documentation organized. And when you see a scary headline, come to sources like this one before you make any decisions. Always verify information through official sources. USCIS is at uscis.gov, CBP is at cbp.gov, the State Department is at travel.state.gov, congress.gov is where you can verify whether any actual legislation has been passed. These are the sources that matter. Social media is not a source. This is Immigration Law Station. We are here to replace fear with facts, to replace rumors with clarity, and to help you stay informed without panic. Immigration is complicated, but it does not have to be terrifying when you understand what is actually happening. If this video helped you, please subscribe to this channel and turn on your notifications so you never miss an update. If you know someone who holds a green card and is worried right now, share this video with them. It might be the most calming thing they see today. And if you have a specific immigration question you want us to cover, leave it in the comments below. We read every single one. Stay informed, stay calm. We will see you in the next video.